So first, my overarching comment would be, you know, these disputes are going to get a lot more complicated unless we go to a single-payer healthcare system. I mean, that takes care of a lot of what we're talking about today.
Then we won't have conferences.
Well, that's right. We'll lose the conference circuit. In response to a couple things that Louise said. One, you know, if our legal framework aims to erase dignitary harms, we're going to have a lot of work to do. I don't think the best way to interpret racial discrimination laws is as taking cognizance and doing everything we can to stamp out dignitary harms. I think it was aimed at dismantling an entire social system that was geared toward the subjugation and marginalization of African Americans. And so I'm concerned about using how we went about dismantling Jim Crow as the template for how we handle cultural disputes today. Now, I'm going to talk about just for a couple of minutes about the Obama administration's exemptions that we've been talking about, those four criteria. I'm going to talk about number 4, about nonprofit status. Before I get there, though, I think the way that Louise framed those, I think, is a very common way of framing those, and it's part of the problem. So she described the first one as whether the organization has a religious purpose. That's not what it says. It's whether the purpose is the inculcation of religious values. There are many religious purposes that are not the inculcation of religious values, which is why that's so controversial. The other thing she said was, you know, that the house of worship is at the center of the religion, and as you move out to other activities, you're moving away from the center toward the periphery. That's a deeply contested, you know, religious assertion there, to say that, you know, the worship is the center and the soup kitchen is closer to the periphery. I don't know that that's the case, and so that's one reason why these criteria are so controversial, because they're so deep, they make such deeply contested assertions about what religion should count. And I know there's reasons why they have these criteria, but it's not self-evident that this gets at the heart of religion in terms
Rob,
of
what about the second one? What about the Title VII?
Oh, you know,
are you more comfortable with that one as a requirement?
Well, I'm more comfortable with it than the first one. I mean, it still is. I think it's perfectly possible for a religious organization to signal to the surrounding community, this is who we are. Would you like to work for us? Consistent with our mission. You know, I don't have a problem with that. Now, you get into some issues where employers occupy such a large segment of the employment market that then you're removing people from their ability to earn a livelihood. I get that. But to me, it's not about an inalienable right of an individual to work for an employer on their own terms without being caused difficulty by the employer's mission. It's more about, does this person still have access to the basic goods and services that we deem as a political community to be essential to participation in our society? The fact that when you're talking about Walmart, I understand it gets a little dicier, but when you have, you know, some of these groups that are bringing suit now, when you have a relatively small company in the grand scheme of things that has been above board all along about who they are and what they stand for, you know, I'm not sure that the individual employee has or should have a trump card over the implications of the mission of that organization. And that brings me to the fourth criteria, which has been the least controversial by far. And I'm not
going to change that now.
Well, I don't know if I will, because I'm of two minds about it as well. But the notion that nonprofit groups are the only ones who should be entitled to an exemption from this, I just think it bears more thought. Especially, so 5 or 6 of the suits have been brought by for-profit businesses. And what has struck me in the free exercise claims especially, and I think it would apply to RFRA as well, is the position that the Obama administration has taken. Because in their briefing in those cases, this is a quote, they said, "A for-profit secular employer by definition does not practice religion." And that's not obvious to me. That's not obvious to me, because we know that a corporation can have a free exercise claim. A religious corporation, a church, they can certainly have a free exercise claim. So does that change when you take on for-profit status? And then we mentioned before the Hercules Court's opinion, where they framed the question, but then they punted on it. But even the way they framed the question is interesting. So here's what the court said. They said, should a closely held corporation owned and operated by a small group of individuals professing adherence to uniform religious beliefs be treated differently than a publicly held corporation owned and operated by a group of stakeholders with diverse religious beliefs? Even that question, so the implication is, well, if it's a closely held corporation, then maybe, but we all know a publicly traded corporation could never bring a claim like this. And I'm not sure why that's the case either. I mean, in many areas, we empower management to speak on behalf of shareholders, even in ways that bind the company. Or if you compare it to a case like Dale versus Boy Scouts, where we said, we're going to defer to what the head of the Boy Scouts of America says their beliefs and their identity is, even if local constituents groups vehemently oppose that. So, you know, it's not obvious really why we would say the ownership management split precludes a religious liberty claim. Then the second question the court asked, is it possible to pierce the veil and disregard the corporate form in this context? The implication of that is, in order to get to their religious liberty claim, you have to go through the corporate form to the individuals. Why would that be so? I mean, do we not have religious liberty claims that accrues to the corporation, to the association of individuals themselves? It's all made more interesting, of course, because of the Citizens United ruling. Right? Because Citizens United, the court says, you know what, we're talking about political free speech. The identity or the status of the speaker is constitutionally irrelevant. So when we get to religious liberty claims, free exercise claims, is the identity or corporate status or form of the speaker relevant now? I mean, we haven't had courts really grapple with this directly. Judge Noonan, in a dissent years ago, said, of course it's not relevant. Of course any organizational form can bring a claim like this.
So let me press you a little bit on the subsidiary arguments that DOJ is making, in addition to the one that Rob just mentioned. I think what's at the heart of DOJ's argument, I don't know that that was the best way to put the argument that corporations can't practice religion, is, as we mentioned, both sides of the RFRA equation. So on the one hand, it offers another way for the person with the religious beliefs, another option for them. They don't have to run the air conditioning company, right? They can do a lot of other things. They don't have to run a corporation at all. They have an option in a way that a religious organization does not, without really totally implicating its religious mission. And you saw this a lot. I'm not necessarily promoting this idea, but certainly the case law, there's these 9th Circuit cases involving the Fair Housing Act and prohibitions in the law against you can't discriminate against non-married or lesbian and gay couples in housing, landlords. And landlords who only owned a few properties would come in and say, I'm against cohabitation. It's my religious beliefs. And one response of the courts was, that's fine, and we sincerely believe you that that's your belief, but you have an option. You don't have to be a landlord, right? So the law isn't imposing a substantial burden on you because you have this out. So that on the one side. And on the other side, of course, is what the other panelists have brought out, which is when you go into the for-profit world, however the exemption should be framed in the nonprofit world, once we cross that barrier into the for-profit world, doesn't the government's interest become dramatically higher because of the risk of many, many more religious objectors and really affecting the marketplace for employees?
Yeah, I think you're right on that last point. And so I think where I would come down on this is for-profit businesses should have standing to raise free exercise claims or anything, but we might need to be moving more toward what Fred Schauer and Paul Horowitz and others have been looking about, this institutional First Amendment, that there are certain core institutions that are important to the infrastructure of free speech or free exercise that get a heightened standard of protection that for-profit businesses would not enjoy. But your first question, though, I will push back on the first question. And that is, well, you know, they don't have to operate the HVAC business, or they don't have to, because you could expand that to such a range of activities. You don't have to be a pharmacist if you're pro-life, right? I mean, you don't have to sell those chicken sandwiches if you're going to, you know, take positions against freedom to marry for gays.
But isn't that in some sense true? I mean, Louise made the point. If you choose to enter into the commercial sphere to make money, you know right away on day one that that brings with it thousands of regulations that you have to abide by.
Well,
you made that choice.
You do, but see, here again, we're getting to some contested religious premises, but it's more implicit in your question, because there is some very, I'm just speaking from the Catholic tradition, there's some very rich theological work on the notion of vocation. Right? So the notion that, well, when you're doing your religious stuff, we understand that's an obligation and a commitment, but now you're just doing something optional. You're going out into the for-profit world. That's just something optional. There is still a lot of theological weight to that. Now, where I would agree with you is, and this is a judgment call, you can't completely redefine the nature of the professional role you've undertaken. So if I was say that if I'm somebody who's strongly opposed to the death penalty, and then I apply for the job as the state executioner, and I say, yes, I am entitled to the job as the state executioner, but I will not participate in the death penalty. Well, of course, that's ridiculous. That's the nature of the job. But a lot of these, so if you're a pharmacist, and when you got your pharmacist license, and then they've introduced Ella and all these other drugs, it's not a case of, well, you should have expected that you were going to be regulated for all these things when you decided to become a pharmacist. You have no grounds to object. There's going to be degrees of difference in here, but the notion that, the nonprofit religious world, that's central to the religious believer's identity and freedom of religion. But then if they open a business that has any dimension of financial profit, that's just something they can put on like a hat and take off without any cost to their own sense of who they are and their religious identity. I would reject that sharp distinction.